rise.
Thank you. Please be seated. Thank you, Mr. Blackburn. Please be seated, and thank you for your time.
Thank you.
Do you wish to swear an oath or affirm?
Affirmation, please.
Then if you would just repeat these words after me. I, Stephen Blackburn,
I, Stephen Blackburn,
sincerely declare and affirm
sincerely declare and affirm
that the evidence that I give to this commission
that the evidence that I give to this commission
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Blackburn. Mr. Shaw.
May I please, Commissioners? Could I ask the operator please to bring up Mr. Blackburn's witness statement? Mr. Blackburn, that is, could you confirm please the first page of your witness statement? Can you see on the screen?
I can. And yes, it appears to be.
And operator, could we please go to dot point 1306? And whilst that has been redacted, that's the final page of the substance of your witness statement.
Yes.
Thank you. I'll come on to the... Oh, actually, I'll deal with this now, Commissioner. And if we can go to the next page, point 1041. That's SB2. At number 10, there's a document referred to there in relation to play period, a May 2021 document. Is it correct that there now is, that document now has been superseded by an updated play period document that bears CRW 701-011-1638? If the operator could please.
Correct.
That's going to be brought up on the screen, but that's the sorry, CRW 701-011-1638. Oh, beg your pardon. That's the 001. 701-011-1638. Yes. Is that the document, Mr. Blackburn?
Yes, it is.
And that is the updated version of document 10, play period document.
Correct.
Commissioners, I tender both the witness statement and I understand that has been uploaded, the updated play period document. I tender both.
Thank you. The witness statement of Stephen Blackburn dated the 23rd of October 2021 and bearing the identifier number CRW.998.0002.01008 with the amendment to item 10 in Schedule SB2 is admitted into evidence as an exhibit.
Thank you.
Thank you, Mr. Shaw. Ms. Cale.
Please, your Commissioner. Mr. Blackburn, you commenced in your role as Chief Compliance and Financial Crime Officer on 24 February of this year, is that right?
That is correct.
And one of the first major tasks that you undertook was to review the Crown Group's then current financial crime and compliance programs?
Correct.
And to advise the Crown Group Board of your assessment of those programs and your plans going forward in relation to them?
That is correct.
And that culminated in a paper that you prepared for the CRL board dated 24 May 2021?
It did.
And I'll ask you to identify it, please, on the screen, CRW.510.073.1795 by reference to the cover page.
I'm sorry, it is slightly difficult to read, but I believe that is it. And that would be the covering paper that presented the associated deck. So there was a package of materials, but that is the paper that was presented to the board.
So can I just ask you why it's hard to read? Do you have the document appearing on the screen?
It's better now. Somebody had brought it up, which is terrific. Somebody zoomed in.
You can't see it on that little screen that's in front of you.
No, this little screen in front of me is relates to the telephone. It's the telephony. The screens are in the distance. However, with the Zoom, it is clear to me.
Okay. Now, accompanying this memorandum, I think you just referred to a PowerPoint presentation, CRW.510.073.1797.
Yes,
That's the cover.
correct.
I just want to explain how my examination will proceed in relation to the AML-CTF topic, Mr. Blackburn. I want to ask you some questions about the current state of the financial crime and compliance programs. I appreciate that your focus is very much on a change program to uplift what is existing, and I intend to ask you about that change program in due course. But first, I want to get some understanding of the program as it sits at the present day. Is that clear?
Yes, it is.
And I'll do so primarily by reference to those two documents that I just showed you. I appreciate we're now some months further down the track from when those documents were prepared in May. When giving you answers, I'd ask you to be conscious of that. And if there has been a material change in the program since then, as it is operating at Perth Casino today, could you please indicate that for the benefit of the commissioners? Is all of that,
happy to.
All of that clear?
It is clear. Yes, thank you.
Returning to your 24 May memo, CRW 510.073.1795. Let me blow that up for Mr. Blackburn to see, please. In the third and fourth paragraphs, drop down please. The third and fourth paragraphs, not the fourth and fifth. You draw a distinction between the financial crime program, which is discussed in the third paragraph, and the compliance program, which is discussed in the fourth. I want to ask you about that distinction in a moment, but can I ask you first about financial crime? Although financial crime is a descriptor to include all sorts of financial crime risks, such as fraud risk, when you speak about financial crime in the context of the Crown Casino operation, you are talking, aren't you, primarily and relevantly about money laundering and terrorism financing?
That is correct.
And you go on to speak about those risks in this paragraph, and you identify that casinos are amongst the industries where the risk of facilitating money laundering and terrorism financing is the greatest. Now, you'd accept, wouldn't you, that the association of casinos with the risk of facilitating money laundering is long and well understood?
I would, yes.
I'll ask you about terrorism financing, though. What is the extent of the risk that casinos face of facilitating terrorism financing?
International experts regard it as low risk, given the nature of the activity, and terrorist financing is more commonly associated with banking through disguised organizations or charities.
And how does terrorism financing, or the risk of terrorism financing through casinos, typically arise?
It arises in the same way as money laundering, so the same indicators are indicative of both money laundering and terrorist financing, in that there is an attempt to clean money to anonymize the original source of the funds.
Thank you. Now, coming back to the financial crime program and the compliance program that you discuss variously in these two paragraphs that are on the page, is it correct to understand the two programs as distinct, albeit that they may overlap?
There's actually very little overlap between compliance and financial crime. Financial crime is a risk function with operational elements that is primarily aimed at compliance with AML/CTF legislation, potentially sanctions legislation to the extent it applies, whereas compliance speaks to a number of compliance requirements across multiple pieces of legislation, multiple jurisdictions, not relating necessarily to financial crime. There is a slight nexus through the Casino Control Act in the context of an objective to minimize infiltration of criminal activity at the casino. But otherwise, the legislation is distinct and separate and apart. The licensing requirements are distinct. So compliance is essentially a separate function.
When you referred to the Casino Control Act there, the Casino Control Act of which jurisdiction?
So Victoria and New South Wales in particular. However, my sense is that the objective would apply in the context of Western Australia as well.
And can I ask you about the financial crime program? Your summary assessment in the third paragraph here, that's the top paragraph that's been highlighted on the screen, is set out there, and you identify work that has been done in the last 18 months. You see in that first sentence, Crown has significantly assisted over the last year and a half.
Yes.
Do you mean there from late 2019?
Yes.
You then go on to reference the depiction of the current state of maturity of what you describe as Crown's financial crime ecosystem, reference to the attached PowerPoint. Is ecosystem here a reference to the financial crime risk identification and management system?
No, ecosystem is intended to capture all elements of the approach to financial crime risk mitigation and management. So if you, and I can take you there, or you may take me there, in the deck that is associated with this paper, there is a diagram that depicts a house. In the diagram, you will see elements, all of the elements of a robust financial crime program, and that is what I consider the ecosystem for financial crime.
Right, thank you. We'll come to the PowerPoint, or I think you call it a deck, do you? A slide deck.
Yes, sorry, I think that may be a Canadian thing. I'm not sure.
Let's just stay with the third paragraph for a moment.
Yes.
Second paragraph. You've got to pop out the third paragraph, please. Do you see in the, I think it's the sixth line, there is a sentence commencing to effectively manage financial crime risk and the associated regulatory risk, and then goes on?
Yes.
Was it your view that as at 24 May, when you wrote this memo, that the Crown Group effectively managed financial crime risk?
Sorry, that is not what that sentence states or was intended to state. It says to effectively manage financial crime risk, you must do the following. That is what the intention was there.
I'm asking
my perspective on
question, Mr. Blackburn. Was it your view that
Sure.
as at 24 May, when you wrote this memo, that the Crown Group effectively managed financial crime risk?
My view at 24th May, which is also articulated elsewhere in this paper and in the associated DAC, is that Crown in aggregate had the foundational requirements for a compliant program.
So just to answer my question, was it your view that as at 24 May, when you wrote this memo, that the Crown Group effectively managed financial crime risk?
My perspective is that in aggregate, Crown had a compliant program that was effective in managing financial crime risk. However, there were opportunities for considerable enhancements across all elements of the ecosystem.
So I'm not asking you whether the in your view, the program was compliant or not, simply whether or not Crown Group effectively managed financial crime risk at 24 May. What is your view?
I would say that Crown, in most ways, was effectively managing financial crime risk, not entirely, and that's why enhancements were required.
Okay. In what respects was it not entirely effectively managing?
In every respect that I set out in the paper, that I assume you've read, and the deck that is associated to that paper, it articulates in each case a maturity assessment of each element of the financial crime ecosystem and program. If I'm happy to take you there if you wish, but you will know that I've indicated that certain elements of the financial crime ecosystem were not at a maturity level that I would expect or hope for an advanced program.
Do you mean a maturity level of initial?
Yes, correct.
And if you assessed an aspect of the program as being at a maturity level of initial, you would say that that was not effective. Is that right?
I would say that it was inadequate.
Well, I'm asking you about whether it was effective or not.
Could I inquire as to why you feel that term is important in the context of the question? Because what I'm attempting to tell you is my view on the maturity of the program as at a certain date, which is an assessment as to the program based on my review over that period of time, as to its maturity and what required further enhancement. I'm not certain I understand the point on the word effective.
So just coming back to your role at Crown.
Yes.
Accept, wouldn't you, that part of your role is to ensure that it has an effective financial crime risk program?
My role is to ensure that the financial crime program at Crown meets all regulatory requirements and regulatory expectations so that we can discharge our obligations under the AML-CTF Act and rules in accordance with those laws.
And it doesn't extend beyond compliance with legislation and regulation, Mr. Blackburn, is that what you're saying? That independently of that, you don't perceive Crown as having a responsibility to effectively manage financial crime risk?
No, those are your words, clearly, and they're also not what I just said, which is the obligation is to not simply comply with regulatory requirements, but also regulators' expectations. My view on financial crime, if you're asking, is that our obligations extend to protect the vulnerable. That is the point of a financial crime program, ultimately, is to focus on those that are vulnerable and to assist those that are vulnerable by mitigating, managing, detecting, deterring, and disrupting financial crime.
Separately from any legislative or regulatory requirements, do you consider it is Crown's responsibility to effectively manage financial crime risk?
Yes, I would.
Did you wish to say?
No, the answer's been given.
Yes, proceed, Ms. Cowell.
Can we go to the PowerPoint, please? CRW 5100731797 at page 1801. You have assessed here each element of the current financial crime program, current as at May 2021. As to your perception of its then level of maturity. Is this the house
Correct.
that you were describing before?
Yes, this is what I describe as the house.
Yeah. And you explain at the top of the page that the aggregate view you've reached is that the program as a whole is foundational.
Correct.
Which is evidence that you gave to the Victorian Royal Commission, wasn't it?
It is.
I don't want to repeat that, Mr. Blackburn, but I do want to understand a little more detail about some of the matters within your assessment of foundational. If we go back to page 1800, please. You describe in both narrative and diagrammatic form here the different stages of development of a financial crime risk program. Is that right?
That's correct.
And you observe that most banks sit somewhere between foundational and advanced in this
Yes.
maturity arc.
I would suggest that's the case based on my understanding of how the banks are currently prepared to meet their financial crime risk obligations. However, I would also say that there is considerable variance amongst the banks.
The point you make here on this page is this, isn't it? That an optimal program, which is the most mature form of a program with the characteristics you identify and the dot points under that, is an appropriate stretch target for banks.
I think it is, and however, I would suggest that depending on the organization, depending on the reporting entity, a large bank versus a small bank, a mid-sized bank, they may have a different strategy. They may aspire to be somewhere between advanced and optimal. Some may aspire to be at optimal. Others may aspire to be at advanced. And
you also observe that none, to your knowledge, have in fact achieved optimal status.
I'm not aware of a global bank, not simply the banks in Australia, but I'm not aware of a global bank that has reached optimal. I think there are many banks and many reporting entities beyond banks that have reached components of optimal, but not necessarily optimal in the entirety of the program. It is a very difficult aspiration, but one that with ongoing investment and resourcing is potentially achievable, depending on the resources of the bank as well.
Now, the observation in the narrative on this page that you make is that that optimal target may not be appropriate as a stretch target for Crown. Can you explain why
Correct.
that is?
Yes, in many ways, the optimal target is modeled on banks, really, or financial institutions that have comprehensive systems across their organizations, maybe in multiple jurisdictions, but also lend themselves to automation in every way. For a casino, as a reporting entity, the aspirational point is a mixture of automation and manual, because observation is a critical component to managing and mitigating financial crime risk at a casino versus that at a bank.
You say in the last sentence of the narrative that the plan that you're propounding in this presentation is distinct from the plans typically deployed at banks. However,
Correct.
Your change program that you are instigating nevertheless conforms to the maturity arc that is diagrammatically represented on this page. Is that right?
That's right. It's more about the how we get there, and how a reporting entity like a casino could aspire to optimal versus how a bank would. In a bank, as I mentioned, automation is far more available and more appropriate in the context of managing and mitigating risk, whereas in a casino it isn't. So that is where it is distinguishable from a bank. It's the elements of where we're aspiring to be are frankly the same, but it's how we get there that may differ.
Right, now, over the page to 1801, this is where you assess individual elements of the current program.
Correct.
Did you do that specifically with reference to the program as it currently exists at Crown Perth?
I did it specifically as relates to the program that exists at Crown Resorts Limited and all of its subsidiaries and all of its reporting entities, Crown Perth, Crown Melbourne, and at some point, Crown Sydney.
So you looked specifically at Crown Perth?
Crown Perth is governed by the same documents that Crown Melbourne and Crown Resorts are. The only difference is the procedural documents, which are business processes, as opposed to the governing documents, which are formed by the AML-CTF program, Parts A and Part B, together with the policy and underlying a large procedure document.
Did you review the standard operating procedures, policy documents, and so forth, which are unique to Crown Perth?
I did not review the procedural documents associated with Crown Perth, as that's a first line function as opposed to a second line function. I did, however, consider Perth in the context of the broader policy documents. The policies that you speak of are, this is part of the challenge, and one of the things I'm attempting to uplift through our policy uplift program and also through the financial crime change program and compliance change program is the framework associated with documents. The policy is essentially a document that underlies the AML-CTF program, which is Part A and Part B of the program. The policy is then also owned by the second line. That is the subsidiary document. Below that are the procedural documents that are owned by the business. I did not review procedural documents at the time of my assessment in May.
We go to page 1802, please. And this is where you begin to look at the key components of the program and assess the maturity of each of those components. Is that right?
Correct.
Just to
That's correct.
What you've done here, are you identifying here the key components of Crown's program as it existed at May 2021, or are you identifying the key components of any financial crime and compliance program and measuring how Crown's program measures against those key components?
So it is a measurement in the context of my expectations. However, the center column, which is the current state, is a reflection of Crown's program as at May 2021,
but
as I understood it.
The left-hand column of components is the components you would expect to see irrespective
Correct.
of whether they're there or not.
Correct.
Understand. Now, the first thing you mentioned is the joint AML-CTF program. And you mentioned Part A and Part B a moment ago.
Correct.
There's also a set of policies and procedures housed in a document that is also comprised that also comprises that program. Is that right?
That's correct. The document title of the AML-CTF program represents Parts A and Parts B of the program, but if you use perhaps a small p, then you would consider the policy and procedure underlying document as part of the overall program.
All right, we'll just identify those documents because we'll come back to them later in this examination.
Happy to.
Mr. Blackburn, CRW.514.002.0110, only on the room screens, please. That's the front page of Part A.
Yes.
And that document was approved by the CRL board in November 2020. Is that right?
That's correct.
And at the same time, there was a Part B document, which is displayed on the right-hand side of the screen as CRW.514.002.0145 that was also approved at that time. But it was then replaced in August 2021. Is that right?
That is correct.
And it's CRW.
That's correct.
We'll identify it CRW.700.102.5742 only on the room screens, please. Sorry, thank you. That is the right one. And CRW.514.002.01 only on the room screens is the accompanying policies and procedures.
Correct.
Now, Part A has not been the subject of any material amendment since it was approved in November 2020.
Yes, that's correct.
By the time of your memo in May 2021, the joint program had not been fully implemented, had it?
It hadn't, no.
Has it been fully implemented now?
My understanding is that it has been fully implemented, but that is not based on testing. We are in the process of building out our testing function that will allow us to confirm with confidence that it in fact has been implemented across the organization.
And when you say the program has been fully implemented, do you include within that answer Part B as it was approved in August 2021?
Correct.
Now, you were obviously not there in November 2020 when the joint program was prepared and then approved by the board. But in terms of reaching your view about its foundational status as at May 2021, you presumably considered whether that program, in particular Part A, was based upon an MLTF risk assessment, did you?
I did.
Were you able to satisfy yourself that the joint program was based upon an ML/TF risk assessment in respect of specifically the Perth casino operations?
I wouldn't have considered it specifically in respect of the Perth casino operations other than as an element of all of the reviews that were undertaken, in particular by external advisors and external consultants, but also in the context of the 2019 review that Mr. Preston conducted and assessed, which I understood to have included Perth as well. Notwithstanding that at the point of his review, the Perth DBG would have been separate and distinct from the CRL DBG, so the designated business group, which was essentially formed through the introduction of the program in 2020.
So for the program that was approved in November 2020,
yes,
you explored and considered whether it had before then been based upon a risk assessment.
I did, yes.
And if I could show you this document, CRL.614.001.0670, was this one of the documents that you identified as forming the basis of the risk assessment that underpinned the joint program?
Not this document specifically, but the outcomes from this document. So the risk register, the AML risk register that was developed pursuant to this or as part of this review is what I considered. But no, this document is new to me.
All right, 673, if we go there, please. Was this document one that you considered as underpinning the joint program approved in November 2020?
I viewed that document. That is a document that was familiar to me as part of my review.
Yep.
Yes.
Did you form the view that this was an assessment that underpinned the November 2020 joint program?
I formed the view that it was one of many assessments that underpinned the risk assessment of the joint program. This in aggregation with or in collection with a number of external reviews, including the promontory review, which was underway at the time. The first phase of that was released, which was intended to act as at least support for the EWRA in that it was identifying vulnerabilities, inherent risk, and assessing what was necessary to reach a lower residual risk rating. But yes, in short, this was one of the documents that I would have considered.
And another one is at 0682. We just go to the next.
If that's yes.
The risk register proceeds for several paragraphs. Correct. Now, when you talk about external reports, you mentioned prominently, I think, a moment ago. Are you saying that that was completed and then brought to account prior to the approval of the joint program in November 2020?
No, certainly not. Certainly not. What I'm saying is that the promontory work was underway. There was consultation on the promontory work. I discussed it a number of times prior to forming an opinion. I also had the benefit of the initialism work from October 2020, which was essentially an assessment of the compliance of the program, which indicated that the program was compliant with applicable law and designed effectively to identify, manage, and mitigate risk. But amongst others, there were a number of reports.
Looking at the position as at November 2020, when the board approved the joint program, the two documents I've just shown to you, do you regard them as adequately assessing the MLTF risk for the Perth casino operations?
Well, that would be a hypothetical because I wasn't in that position, because my opinion is as of May of 2021. However, if I were in that circumstance and if I were presenting it, if it were solely based on those two documents, I do not feel that would be adequate for a more comprehensive understanding of risk.
Can we come back to the policy and procedures? This is just on the in-room screens, please. CRW 514-002-0001. At page 0082. There's a risk assessment methodology published 16 October 2020. With respect to the Perth casino operations, are you able to say whether the MLTF risk assessment on which the current joint program is based was prepared in accordance with this methodology?
I'd be unable to say.
At 0084, it refers to the methodology including certain dimensions which appear in the dot points. With respect to the Perth casino operations, those two documents that I showed you before, the memo and the risk register, in your view, do they include those same dimensions?
Having reviewed them, as I mentioned, sorry, in respect of the two documents that I did review, you mean, do these comply with, could you just repeat the question?
So I showed you before a memo that contained a risk assessment in relation to Crown Perth and a risk register.
Yes.
In your view, do those two documents conform to this methodology in the sense of including these same dimensions for assessment?
I think I'd need to consider that, but my initial reaction is no.
Now at 0087, there's a risk assessment model as part of the methodology that includes certain categories, subcategories and risks as are set out there in those columns. Those two documents that I took you to earlier, in your view, do they conform to that risk assessment model?
Again, I'd need to consider it more deeply, but based on a fairly cursory review, I would say no.
Now, the methodology at 0085 refers to the need to assess both inherent and residual risk.
Yes.
With the residual risk being assessed after taking into consideration the existence and operational effectiveness of controls that are put in place to mitigate the risk being assessed. And if we go to the risk assessment documents, CRL 614-001-0670 at 0673, this is that memo that I showed you. Over the page,
Yes.
Do you see at the top, the residual risk rating for potential MLTF activity at Crown is low? See that?
Yes.
Would you agree?
I do.
Would you agree with hindsight that that was not an adequate assessment of residual risk?
I would agree with that. Yes.
And your agreement in hindsight is informed by, amongst other things, the outworkings of the Bergen inquiry.
I don't think that would have changed my opinion. I certainly appreciate the outcome of the Bergen inquiry, and I don't disagree with that element of it. But my opinions on its own would be that that was a curious result.
All right, now looking at the PowerPoint presentation from May, CRW 5100731797 at page 1802. Moving on from the joint AML-CTF program component, you'll see if we skip people and governance and go down to enterprise-wide risk assessment.
Yes.
Now, this is an important component of any program as far as you're concerned.
It is indeed.
Yeah. And can I just understand what you mean by an enterprise-wide risk assessment? Do you mean an assessment across Crown's entire business to identify comprehensively all financial crime risks?
Yeah, I would suggest it's broader than that. It starts with, so there are 4 core elements to a financial crime enterprise-wide risk assessment. The 4 core elements are customer risk, product risk, channel risk, and jurisdiction risk. Each of those components has several elements to it in order to determine the inherent and residual risk. Then taking those, accumulating them, looking at the objective evidence of the risk and the exposure across those 4 elements, then considering controls against those risks to determine whether or not, or what your residual risk outcome is. That to me, and also doing it across, not simply across those elements, but also across your business lines by business unit. So in particular, where designated services are provided by specific business units, including at Crown Perth and the elements of those businesses and products at Crown Perth, it would be in respect of each of those at an initial level, and then aggregated for the purpose of the entire organization.
Now, the objective though is this, isn't it, of that method and approach, is to, as far as is possible, comprehensively identify across the enterprise the financial crime risk that arises.
That's correct.
Yeah. Because unless an enterprise or business has comprehensively identified all material financial crime risks, it can't be confident that it's adequately managing its risks. Would you agree with that?
Yeah, I would agree with it in part. I think it simplifies it perhaps too much, in that there are several elements to the risk, and you can have components of the risk assessed which give you insight into your foundational risks, your fundamental risks, your inherent risks, and certain controls, an assessment of certain controls that may form part of your view of residual risks. But at some point or another, it is extraordinarily helpful to have, which is why I proposed it, a consolidated enterprise-wide risk assessment. It's not fundamental or necessary to ensure that you are fully identifying your risks, but it is incredibly helpful as a tool.
And at this page 182 of the presentation, you assess the enterprise-wide risk assessment for Crown as somewhere between initial and foundational. Is that right?
Correct.
By which
Correct.
you mean it has moved beyond initial and is heading towards, but has not yet reached the characteristics of foundational expressed at page 1800.
That was my opinion at the time, yes.
Having regard to the objective that you've described of an enterprise-wide risk assessment, when you prepared your main memo to the board and the PowerPoint presentation, had you formed a view then about whether money laundering and terrorism financing risks specifically had been comprehensively assessed across the whole of Crown Casino's operations?
I formed the view that money laundering and terrorist financing risks had been assessed, at least in part. I wouldn't have assessed it as complete or comprehensive and as you can see, I indicated that it was somewhere between initial and foundational. For me, foundational would mean that every element had been comprehensively assessed and residual risk was fully understood.
And the current joint program,
Yes.
as it sits presently, do you say that that is based upon an enterprise-wide risk assessment?
I would say that it is based on multiple risk assessments that in aggregate form an enterprise-wide risk assessment. But again, the program as it stood in November 2020, I don't have the benefit of understanding what all was considered, but you've identified two documents that presumably were considered as part of that risk assessment, the underlying risk assessment. In my assessment, there were additional materials that I could cite to consider the risk, including external reviews.
Yeah, but they post-dated November 2020.
Correct.
Yeah.
Well, I suppose with the exception of Neil Jean's initialism review of October 2020, but just by way of reminder, that assessment indicated that Crown's program was compliant and designed effectively to meet, to identify, manage, and mitigate risk. And that is an opinion that can only be based on a determination that there is an underlying enterprise-wide risk assessment that's adequate for the purpose of the program.
The two documents that I took you to before that we've been discussing,
Yes.
You don't contend that they constitute an enterprise-wide risk assessment separately or together?
In my view, if they were the sole documents that were considered for the purpose of risk assessment, I would not feel they were adequate.
It's the case.
But I suspect, depending on the expert you're engaging, you may have a different answer.
It's the case, isn't it, that PwC has been retained to prepare an enterprise-wide risk assessment for Crown now?
To assist with the preparation, yes.
With a focus specifically on MLTF risk?
Correct.
And it seems from paragraph 131 of your witness statement that that's due to be completed this month and to be sent to the board for approval in December.
For noting in December, but yes, correct.
And just to understand precisely what PwC is doing, can we go to this document, CRW.700.100.1664? So you'll recognise this document, Mr. Blackburn, the Transformation Program Steering Committee. It's a PowerPoint presentation dated 6 October 2021.
I do recognise that, yes.
And if we go to page 1696, here we're deep in the part that deals with the financial crime and compliance change program for which you are responsible.
Correct.
And did you either prepare or approve such of the contents of this PowerPoint presentation that relate to that change program?
I reviewed the content and was comfortable with it.
Right. Now, over the page at 1697, you see in that right-hand column, there's a reference D1. You see that row, D1?
Yes, I do.
And that's a reference to developing, executing and signing off on the EWRA.
Yes.
And that's simply the methodology document, is it? Or is it actually an assessment of risk itself?
It's the result.
All right. But that's just for this financial year?
Correct. That is typically how you do EWRAs is on an annual basis. So it would be for the last financial year.
Although if we look at D2, is the idea there that once the assessment for this financial year has been completed, there's a task that's to be undertaken to produce a process that will be able to be deployed year on year?
That's correct. In my experience, EWRA should never be singular events. They must be ongoing events, and they must actually have components that occur over the course of the fiscal year, not simply at the end of the fiscal year.
Right, so the D1 task, therefore, and what's going off to the board for approval, is it next month, is
Correct.
in effect an interim methodology or process that is to be further refined next year.
My view is that every EWRA is an interim process in that it requires continuous evolution, in the context of financial crime being an ever-evolving challenge. So I don't think one could ever say that you'd have a truly effective EWRA to meet all risks at all times. You need to continue to evolve it.
Accepting that the D1 exercise is not intended to be repeatable, whereas the D2 exercise is. You'd agree?
Oh no, D1 is foundational for D2. You can't have D2 without D1. So they must be read in conjunction.
Now, just having a look at the timeframes here, is Crown on track to meet those timeframes in the right-hand column in respect of D1 and D2?
We are indeed.
So in relation to D2, the design of the EWRA process refinement is to be completed by more or less the end of the year. When will that go to the Board of CRL for approval?
Well, it will continuously go to the board. So every year, the EWRA, so our approach to EWRA going forward, which will be captured in the program, in Part A of the program, will be to conduct an EWRA on an annual basis. And it will consistently build on the previous year's EWRA, but you look at the objective evidence from that period in time, so that fiscal year. So presumably I will take, whenever the redesign is ready, I will take it to the board for noting, as opposed to approval, simply to inform them of what we've done to change the program and what we continue to do to change the program and the likely outcomes of those changes.
The D2 exercise is distinct from an annual assessment though, isn't it?
I wouldn't say so, no, in that D2 is required for your continued evolution. So the D2 process is kind of fundamental, frankly, to having an effective and ongoing robust EWRA.
Yeah, but there'll be a separate FY22 MLTF EWRA.
Certainly will, yes.
That'll be a separate task.
Correct. Yes, each year there'll be a separate task that builds on the last.
So will the D2 EWRA process refinement task culminate in a document to be approved by the CRL board?
To be noted by the CRL board, yes.
When will that happen?
At the end of the calendar year for 2022.
And for Burswood Limited, the board of Burswood Limited?
For noting as well, same period of time.
Now, if we come back to your witness statement, please, at paragraph 133, page 1030. You refer to a risk assessment framework document dated August 2021. Just
Yes.
the hearing room screens, please, if we can open up that document, CRW.700.102.5470. Can I ask you what relationship this document bears, if any, to the EWRA?
This is a foundational document. It's, if you will, a constating document for the purpose of the EWRA. It sets out the framework and approach. So essentially the design of the overall approach to constructing the EWRA, the financial crime EWRA.
Just keep that document sort of virtually tagged, if you will, with a finger on it, and go back to your witness statement at 122, page 1028. Something I want to understand about your evidence here. The effect of paragraph 122, as I understand it, is to say that the risk of facilitating financial crime at each Crown casino is, in your view, virtually identical. Is that right?
Yes.
if we go back to the document I've just shown you on page 5478, under the heading Considerations on the left, you see the second sentence where it talks about inherent risk profiles for similar products may differ across Crown locations as a result
Yes, that's correct.
of regulatory requirements. You don't disagree with that proposition?
I don't.
So does that mean, therefore, that the risk profiles may not be virtually identical across different locations?
It will entirely depend on, so the fundamentals of the underlying risks are the same. The approaches by the criminals for facilitating money laundering and the typologies associated with the criminal activities are consistent across jurisdiction. It may differ based on, for example, the number of EGMs in a location versus the absence of EGMs in a location. So it could differ based on the products. It could differ based on channels if there were a difference in channels. At this point, there isn't. And it could differ based on customers. So when you're conducting the customer risk assessment, you will determine how many of your customers are high risk, moderate risk, or low risk. That may differ jurisdiction to jurisdiction, which ultimately means the EWRA for each jurisdiction may be slightly different, but ultimately addressing and managing the same underlying risks.
So are there two EWRAs for financial year 2021, one for Melbourne and one for Perth?
There will be three, in fact. There will be one for Melbourne, one for Perth, and one for Sydney, all of which aggregate into the global EWRA, which is the CRL.
Right, so if we go back to CRW 700, 100, 1664 at page 1697, that task D1 actually refers to three separate assessments, does it?
Yeah, I wouldn't necessarily call them separate assessments in that they're looking at the same components. They're just looking at it for different jurisdictions. But the components are, frankly, identical. As I said, you're looking at channel risk, you're looking at product risk, customer risk, and jurisdiction risk. So the assessments, the methodology behind the assessments is virtually identical. It's just applied to different data sets.
So if I can just ask you to look at this document then, and I think it's also just in the hearing room, CRW.701.011.2255, which is something that's been provided recently to the Commission as a working draft of the EWRA dated November 2021.
Yes.
Is that for a particular property, or does it deal with different properties in different ways? Or
I have yet to review this document. I reviewed it last night when the PCRC, or when it was indicated that you'd be taking me to this document, but it is not yet in a position to be shared with me.
so you wouldn't be able to say, so I'll go back a step, who's prepared this to your knowledge?
So it would be my team, members of my team, particularly those responsible for financial crime risk governance, together with the PwC help.
Is it nearing finalisation?
Actually, sorry, apologies, I'm wrong on that, because I did check late last night if my team had seen it. I understand that this was prepared by PwC and has yet to be vetted by either Crown, by my team at Crown, or by myself.
All right. Is it nearing finalisation to your knowledge, or you're just unable to say because it hasn't been vetted by Crown?
I don't know. I simply haven't reviewed it yet, so I'm not certain.
Coming back to CRW 700, 100, 1664 at page 1697, does this document that I've just shown you relate to the task at D1 or the task at D2 or neither?
It would likely be an underlying task for D1. It would be the first part of it, so development primarily.
All right, now let's come back to the draft EWRA of November 2021.
Sorry, before we move to that, can I just then ask, there are various due dates on the right-hand side under D1.
Correct.
Do they represent different documents or the design, implementation and embedding of the one document?
The latter. It's the design, implementation, and embedding of the final document.
So that document that Ms Cahill took you to, I'm still just unsure as to, is that the document that should have been finished by the 30th of September or?
The document that was referred to moments earlier, the August document, which was the MLTF framework document, was the design element of the overall EWRA. So that would be reflected in the first category.
So I'm just then I don't understand why you haven't reviewed it at this point.
I have reviewed the design document, so the framework document, but I've not reviewed the result or the initial draft results, which would underlie the implementation document.
But would I be right then in assuming that by the 25th of November, you and your team are supposed to have done that?
That is the expectation, yes.
Thank you, Ms Cahill.
Commissioner. And what else by the 25th of November? Just reviewing that document and finalising it, or something else?
No, that is the task ahead.
That is the task of implementing the EWRA.
Finalising the document for implementation, and then embedding following board noting.
So it will be embedded between the 25th of November and the 17th of December.
Correct.
And what does that actually mean?
The results of the EWRA will inform our approach to many different things. It will inform our approach to policy change. Some of that policy change may happen immediately, but what it will do through embedment is trigger a number of other actions that flow from the data collected and the results of the assessment.
Right, if we come back to the draft EWRA for discussion, CRW 7010112255 at page 2273. Accepting that this has not been vetted by Crown, Mr. Blackburn, do you see in the first paragraph there's a comment? Can we pop that out for Mr. Blackburn, please? That first paragraph, there's comment. It's at the top of the page, please, the first paragraph. Thank you. There's some commentary about the limitations that have been encountered. And in the second sentence, it explains that these challenges are not uncommon, specifically for those undertaking baseline EWRAs such as Crown.
Yes.
Would you regard Crown as now undertaking a baseline EWRA?
Yes, I would.
Which means, does it, that Crown has not previously undertaken an EWRA?
No. I think it's the definition of EWRA. So EWRAs can be constructed based on multiple reports and reviews and assessments, or on a singular one. This baseline one is a singular EWRA, and that will be what I intend to deliver in December.
At 2275, section 4.3.
If I might just or provide some additional comments on the context of EWRAs, if you will. The point of an EWRA, as you probably appreciate, is to understand the underlying risks associated with your designated services. The designated services in the context of a casino are relatively straightforward. It's not the same as in the banking industry, where you have a great deal of complexity across the designated services, the channels, the products, et cetera. In the context of a casino, there's a limited number of products, very limited number of channels, particularly in a pandemic environment, and all of these in aggregate present a relatively straightforward process for enterprise-wide risk. In conducting that enterprise-wide risk, there are many, many helpful inputs. And some of those helpful inputs are things like external reviews, where they've identified risks, they've identified vulnerabilities, they've identified appropriate controls, because it assists you in understanding whether or not you have the correct controls to manage the risks. And I think you'll probably recall that in the Deloitte forensic assessment that was commissioned out of the Bergen inquiry, the result of the phase 3 of that indicated that Crown had built appropriate controls to mitigate, manage, and to mitigate and manage the financial crime risk associated with 10 criminal typologies. That is the inherent risk that you're looking at. The 10 criminal typologies represent inherent risk. And then you assess the controls. At that point, you determine whether or not those controls are effective. Happily for us, Deloitte indicated that they believe our controls are effective, though not sustainable until such time as we automate more of them. But these are the sort of fundamental underlying components of an EWRA, and why we, frankly, why I was able to say in May that it wasn't completely initial, because we did have foundational elements that I could rely on to determine whether or not the underlying risks were understood.
See section 4.3, the first sentence there on the screen. Can you tell me whether you agree or disagree?
Can I ask, Commissioner, could Mr Blackburn be given the opportunity, before being drilled on paragraph 4.3, to read as much of the document as he wishes to?
Do you need to put this in context, Mr Blackburn? If you do, please let us know.
If I could take 2 minutes, that would be terrific, just to quickly have a look at the document.
Certainly.
I don't have a problem with that, Commissioner, just as long as it's understood that Mr Blackburn was specifically given the documents ahead of time yesterday in order to avoid this delay.
Yes, but let him remind himself of what's in, so if you could pull that out, please.
Well,
that would be terrific. Thank you very much. I do have a paper copy here that I will reference.
Just to be entirely clear in relation to the delivery of the document that Mr Blackburn can examine, if one counts the number of pages, so run
Mr Blackburn?
Yes.
We would be due to have a break in 5 minutes' time, so I won't object if we break now, and you can have a look over the break. We'll take 20 minutes and come back at it'll be 11:30 our time, which will be sort of 2:30, I think, your time.
Terrific. Thank you very much.
Right, 11:30. Please be seated. Thank you, Mr. Blackburn. Ms. Cale.
Thank you, Commissioner. Mr. Blackburn, on the screen is the first paragraph of heading section 4.3 in the working draft of the EWRA.
Yes.
My question is whether you agree with the statement in the first sentence.
I don't agree with anything in that paragraph.
You don't agree?
No.
All right. So where it says there's no standalone risk assessments for the product, customer, jurisdiction and channel categories that have previously been conducted and documented, you say there have been?
I would say we have a product risk assessment, we have a customer risk assessment, a jurisdiction risk assessment, and a channel risk assessment. I think perhaps the semantics hang on standalone. I'm not sure what that means in this context, but we have operating assessments for all 4 of those elements.
And you would disagree with the proposition that seems to be implicit in this sentence, that whatever has been done could not be considered as an input into the EWRA?
Yeah, I definitely disagree with that.
Right, thank you. Can I come back to your witness statement, please, at 147 with 1043? Give some evidence there about the EWRA identifying MLTF risk associated with the planned VIP business of Crown Perth.
Correct.
What is the planned VIP business of Crown Perth?
My understanding is that it's a consideration of customers with high net worth that may be considered VIPs for gambling purposes, but I'm not fully across the VIP plans.
All right, thank you.
I am comfortable, though, that whatever customers we introduce will be assessed through our new customer risk assessment methodology, which will then feed into the EWRA, allowing us to understand the risk posed by those customers and the residual and the controls intended to manage those risks.
I just want to clarify something about the joint program in its current form, Mr. Blackburn.
Yes.
To your knowledge, both before your arrival at Crown in February and since then, from about mid-2020, Crown has implemented a number of specific controls to mitigate the risk of money laundering through its casino operations. You agree?
We have indeed, yes.
And not exclusively, but in many respects, those measures have been undertaken as an outworking of the consequences of the Bergen inquiry.
I'm not sure that's a fair conclusion. I would suggest they've been taken in part because of the work that we're doing for the Financial Crime and Compliance Change Program, which is intended to uplift and enhance every element of the FC ecosystem. So there were elements, and I think you'll agree that there were elements in the May 24 board paper and pack that are not reflected in the Bergen inquiry. The Bergen inquiry was relatively specific to 3 typologies of criminal type activity. Our steps have gone far beyond that.
Yes, so you did hear my question that I said not exclusively, but since...
I apologize. I apologize. I didn't hear you say that, but I understand.
Yeah, and at least some of the responses have been as a consequence of the outworkings of the Bergen inquiry.
I would expect that, yes.
And would you agree with me that the change program itself is, in essence, a consequence of the outworkings of the Bergen inquiry?
I don't think so, and here's why I'd suggest not. I think that probably contributed to it. But my being hired at Crown was initiated by the former CEO Ken Barton, before the Bergen inquiry presented its report. It was subsequent to that. Now, much of the Bergen inquiry had occurred by that point in time, so I imagine that partially motivated his actions. But in my assessment of Ken's intention in hiring me was to evolve the financial crime and compliance program at Crown to be world leading. And that is what I understood as the motivation for bringing me in. I was determined to do a financial crime and compliance change program from the day I stepped into Crown, recognizing that that was a value that I could add in advancing Crown's program, and ultimately in advancing the altruistic goal of managing crime.
Now, these changes that have occurred since mid-2020, whatever the rationale for them or the motivation,
yes,
your change program or Bergen findings or whatever, am I right
yes,
in understanding that the steps that have been taken in that regard have not yet found their way into Part A of the joint program as it is documented?
That is correct. They are above and beyond the requirements of Part A. So they are essentially excessive or enhancement steps that will supplement what we're currently doing through Part A.
And are they reflected at a more granular level of detail, for example, in policies and procedures?
They have been incorporated into some policies and procedures, as I understand it, but there is documentary evidence of every change we've made. Where it resides will depend on the change.
And there will be some elements of the program, perhaps specifically the policies and procedures component of it, which will need to be updated to reflect these measures that have been undertaken?
Correct.
Now, you mention at paragraphs 134 and 135 of your witness statement at 1030 to 1031 that it is intended to amend the joint program as a whole.
To simplify our hierarchy, yes.
Yeah. And the intention is to present the amendment of the program to the board of CRL for approval in December 2021, is that right?
Part A, correct.
Just Part A?
Yes, that's the only component that is required to be approved at the board level under the AML-CTF Act and rules.
So when is the program as a whole, the completion of the amendment time to occur?
The remainder of the program, so Part B of the program, will incorporate much of what is currently in the policy and procedure document that underlies the two. And that will also be presented to the board at the same session for noting.
All right. So the program as a whole will be,
yes.
The amendments will be complete by the end of next month?
Yes, correct.
Right. And what is the current status of the amendments?
They're well progressed. We anticipate that we will be in a position to circulate a document relatively soon, so well before, obviously, it's presented to the board.
Now, 135, you say it's anticipated that systems, controls and substantive obligations described in the existing program will not substantially change as a result of the revisions that you describe in 134. But Part A will need to change materially, won't it, to address the change in controls that has occurred since mid-2020?
Well, the Part A was, in my opinion, very well drafted. The November 2020 Part A was very well drafted to accommodate all kinds of flexibility and change over time. And therefore, the changes actually will not be significant. There will be some, certainly, to clarify the risk-based approach in certain circumstances, and also to change certain binary obligations. However, by and large, Part A is a well-drafted document that should serve the purpose of further change.
Can we go to page 1043 of your witness statement, please? And you see, this is the annexure of the different reviews that have been conducted in relation to the risk program.
Yes.
In the status column, the first box, if you like,
Yes.
talks in the second paragraph about the final action item, the independent review of Part A will commence
Yes.
before 31 December.
Correct.
Well, that might lead to material changes to Part A, might it not?
It could, and I should hope that it would. My expectation out of any independent review is that it's a helpful instrument to ensure that you're managing risk effectively. And so I will expect that the consultant that we've engaged to conduct that work will identify issues. And as part of our ongoing evolution, we will be required to update our program following the independent review. I'm not sure I've ever seen an instance where a program has not been updated based on an independent review. Otherwise, it's not really worth the exercise.
And who is the independent reviewer that's been retained to conduct that assessment?
Exeger.
And therefore, presumably, if the Part A is then updated, it will then need to go back to the board again for approval. Is that right?
It sure will, yeah.
What's the time frame for that to occur?
Well, typically a review of that nature, a comprehensive review to understand whether or not the program is compliant and designed effectively to mitigate and manage the risk, will take up to 4 months. That's assuming that the control assessment is robust and complete. So I would anticipate we're probably looking at June of 2022 as the next return to the board for approval of a updated Part A. It could be after that, depending on implementation time.
Now, the enterprise-wide risk assessment that's being completed now,
Yes,
that will go to the board for noting next month, is that right?
correct.
And might that EWRA also lead to changes to Part A?
I would expect that it will. Your Part A is something like a living, breathing instrument in the financial crime world. You should anticipate that you are changing your Part A relatively frequently to respond to new risks, new challenges, new control obstacles, things of that nature.
So how is the EWRA that is to be completed by next month and to be noted by the board going to interact with the independent review? So
I suspect we will probably approach the changes to Part A simultaneously, but it really depends on the outcomes of the EWRA. If there are any significant and material outcomes of the EWRA that we feel must be changed more urgently, then the approach will be to access the board earlier.
now at paragraph 145 of your witness statement, page 1033, you are responding to a question there where you're asked to assess the sufficiency or effectiveness of the revised joint program to be presented in December 2021. You don't answer that question directly. Instead, you say the draft program will not be adopted until your team and you are satisfied as to its efficiency and effectiveness. My question is this, Mr. Blackburn, are you presently satisfied as to the sufficiency and effectiveness of the draft program in the state it currently is in?
Of the draft program, I can't reach a conclusion until such time as the program is complete. We're continuing to work on that program and incorporate change as we progress. And even as we progress, much of the work for the EWRA, for example, is complete. The assessment, the objective review of controls, et cetera. So as that continues, we have further opportunities to alter Part A prior to presenting it to the board, and Part B, frankly, prior to noting for the board. So sort of a difficult one for me to answer without the context.
It's going to go to the board for approval next month.
For noting next month, and the Part A for the board for approval next month. Yes, correct.
but it's not yet in a sufficient form that you can opine on its sufficiency or adequacy. Is that the effect of your evidence?
That is accurate. I would suggest that is always the case with respect to a Part A of your program. You should always be aware of evolving threats, evolving changes, and ensuring that you incorporate those at every opportunity you have, which is precisely what we're doing right now.
Well, there's a difference between a document being the subject of continuous improvement and alive to evolving threats, and an assessment of its current state in terms of effectiveness.
Is there really, in the capacity of a financial crime program? I disagree with that comment and that conclusion. In fact, I think your Part A needs to necessarily respond to evolving threats. It needs to respond to evolving information. As you know, we've had a number of external reviewers provide commentary on our program, provide commentary on elements of our program. All of those are necessary inputs into determining whether or not Part A is satisfactory. We've most recently received Deloitte's Phase 2 results, which will invariably impact our Part A. So I feel that Part A must continue to evolve on an ongoing basis, and until it is sort of presented to the board, it's not to be presented to the board until it's ready, and then it will continue to evolve after that. So there will always be a caveat that it will continue to evolve over time.
But you're not suggesting that you cannot assess the sufficiency and effectiveness of the program at a point in time?
You can draw a line in the sand. However, I would say at this point in time, we have too many inputs coming in to determine whether or not for me to assess it at this point in time. I need to ensure that all of those inputs are taken into consideration, including the results of the Victoria Royal Commission, including, frankly, the outcome of the PCRC as well.
So you wouldn't be prepared to opine on the sufficiency or effectiveness of the joint program until after this Commission's report is delivered? Is that what you're saying?
No, I will. Oh, goodness, no. No, I happily will be taking into account much of what comes out of the Perth Royal Commission, as it's incredibly relevant to the work we're doing in the financial crime space. So I'm keen to ensure that everything that is addressed through the Perth Royal Commission finds its way into our program.
If we go to page 1035 of your witness statement, paragraph 153, you were asked about specific steps or measures to be taken to implement the joint program, and you explained that those are yet to be determined. Is that because the joint program itself is not in a sufficiently final state?
That would be one factor, yes.
And what are the other factors?
We need to determine the outcome from the EWRA that's relevant to determining how we proceed with the implementation of the program, amongst others.
A little bit later, Mr. Blackburn, I want to ask you in a bit more detail about timeframes for the change program.
Yes.
But can I just ask you this now? Because you've not yet determined the steps or measures to be taken to implement the joint program, does that mean that you're not able, as we sit here, to say how long it will take to implement the new joint program?
I think that's a fair conclusion. It's difficult for me to assess how long it will take to implement the program until we have the EWRA in particular completed and the new program finalized. However, I think in response to that question as well, we have a framework for the approach, and this is a sort of tried and tested framework that has been applied at other reporting entities, including in my experience, and that will be the framework we follow. The specifics of that framework are yet to be determined.
I just want to go to the last sentence of your witness statement at page 1036. You say, while there's no timeline for implementation, at present you don't anticipate that the revisions will necessitate significant operational changes. Whether it will or won't, depends upon such things as what the independent reviewer has to say. You would agree?
I would agree, and that's why there will be continued changes over time once we receive the results from the independent review that we will then incorporate into the program and then incorporate and embed at the organization. It's an iterative process.
And it'll depend on what the EWRA throws up?
Well, the EWRA will certainly have relevance to what we implement, but I think just in response to your question, the question 41 was a question as to the implementation of the AML-CTF program, capital P program. So that's the implementation of Part A and Part B of the program. That is where I would suggest that I don't anticipate significant operational changes in that program is, as I said, relatively well drafted to allow for a flexible approach and, of course, allow for a risk-based approach, which is permitted under the AML-CTF Act and rules.
But the actual implementation of the new joint program will involve policy uplift, won't it?
Procedural uplift.
Yes.
Policy uplift. So one of the challenges in Australian AML-CTF legislation is that we call policy program. And so the two are often used interchangeably. Just to define between the two, the program is a defined term under the AML-CTF Act and rules. The program may change, as I said, but I don't anticipate that it will change in material ways because it is fairly well drafted to begin with. The procedures that flow from that program, so if policy, if small p policy, if I may be impacted and they may change, and yes, that will lead to further implementation of changes in procedures.
And you'll need to understand how much training or change in resourcing is required as a result of amendments to Part A and the joint program as a whole. Would you agree?
I would, but I'm very pleased to advise that I anticipated this change, which is why on May 24th, I requested an additional 56 employees in the financial crime and compliance space to supplement the existing 55 so that we could anticipate change. And that is why I have built out the team in the manner that I have. But it's also why wherever I've identified any challenges in the context of staffing, and I have identified issues in the context of resources, I've sought approval and obtained approval from Steve McCann from the board to retain external support. So PwC has been providing us incredible support, frankly, and that will continue until such time as I'm satisfied that our existing resources can manage the risk.
Has any of that additional resourcing that you've anticipated and been provided been at the first line of defence level?
No, but that's the distinction between reporting entities that I think is relatively important to make. The first line of defense, so let me clarify. Reporting entities, of course, depending on the nature of the designated services, differ greatly. In the context of financial institutions, you will see considerable resources in the first line dedicated solely to financial crime. That is a normal course in a very, very large organization with considerable revenue. That is typically how the risk is managed. In smaller organizations, smaller reporting entities, typically you have a spread of where your resources reside. And in coming into Crown, I made the choice, this was a distinction from my time at NAB, I made the choice of including operational functions in the second line, so on my team. So by way of example, we are doing customer due diligence. We are doing enhanced customer due diligence. We are doing investigative processes, all in the second line on my team. That is something you would typically see in the first line of defense at a very large organization, but not typical at a smaller organization. So I think it's important to note that the uptick in first line resources, there may be some requirement, and I noted that in my paper of May 24th, I noted that there would be some expectation that in technology we may require additional resources, in procurement we may require additional resources, and it could be that we require additional resources in the sort of initial triage of CDD, of customer due diligence in the first line. But I do not anticipate that there will be material change required in the first line because I've taken on that task in the second line.
Can I want to change topics slightly now and ask you specifically about transaction monitoring, Mr. Blackburn. Can we return to your PowerPoint from May 2021 COW 51007319797 and look at the last text box on page 1802? You identify the introduction of an automated monitoring system called Sentinel in February 2021.
Yes.
A move to automation in transaction monitoring is desirable from a financial crime risk point of view, isn't it?
Yes, I think it's more than desirable. It's fundamentally necessary in some circumstances. However, it must always be supplemented through manual review in some circumstances.
Now, the choice of Sentinel as an automated system was made before your arrival at Crown, was it?
That's correct.
And you perceive that the Sentinel system has its limitations, don't you?
I do. I will say that I agree with Alex Carmichael from Promontory when he suggested that our transaction monitoring system is fit for purpose. However, I think there are opportunities to improve it. And in fact, what I'd like to be able to do over time is increase the sophistication of the application of rules, which is why I've created a transaction monitoring rules council to assess the effectiveness of our rules and determining whether or not they are resulting in false positives or positives from a reporting perspective. So there will be change over time.
If we go to page 1820, and here you are discussing different systems. Obviously, the first one's a manual system. But here, together with Psycho and Cura, you identify a number of limitations of each of those systems and the Sentinel system. Is that right?
That's correct. One of the challenges that we face in the casino industry for financial crime that is not common in the banking industry, or frankly, even in the MSB industry, or money service business industry, is that there are no off-the-shelf financial crime products. We can't simply go to a SaaS or an Actimize and buy a product that works for financial crime mitigation, rules, case management, et cetera. And so what casinos typically have done is cobble together a number of solutions that support your approach to financial crime. One thing that we are doing, however, and I'm quite excited about, is we're introducing a case manager to replace our current approach to case management that will directly link into the Sentinel system, allowing the analysts and the investigators what is essentially the holy grail in our business, which is the one client view. So we are progressing with technology alternatives that will make it easier and more effective, our process for identifying and reporting.
So this point that you made a moment ago about there not being one single system off the shelf that's suitable for casinos, if we go over the next page, you've identified more of the current key systems down the left-hand side of the page, and you note that they've all got their limitations.
Correct.
The following page at 1822, your point is...
I will say that, so just momentarily, but I will say that even at the most sophisticated organizations, you typically have a suite of products that you use. You'll rarely find an instance where you have a single product. And I can tell you from my past experience at National Australia Bank and also at the Canadian Imperial Bank of Commerce, systems can be a great source of frustration depending on how they interact. And one thing that I was surprised by at Crown is that, notwithstanding the limitations of our systems, they are more flexible in our ability to change them to suit our needs, should we determine that they are the right solution.
So understanding that typically there are a number of systems that are deployed in an organisation, nevertheless, the point you're making at 1822 is that Crown's systems need to be rationalised as well as updated.
And I agree with that. I continue to hold that opinion.
And ideally what you would like is a one-stop shop where customer information across all properties would be accessible in one place. Is that right?
That's right. In aggregate, I want the ability to pull together data, analyze that data, and present it in a single platform. Now, that is as I said, that is essentially the holy grail in the financial crime industry. And it is something I aspire to, but I am not confident that, I certainly, based on my experience, it is a difficult thing to achieve.
Do I understand if we go back to 1821, where we look at right down the bottom that Daon Data Zoo, I hope I'm pronouncing that all correctly, system.
Yes.
Are you contemplating that ought to be rolled out across all the properties?
It's certainly a possibility. We're considering it, but we're also considering it. So any systems that we currently have, my view is that each jurisdiction should benefit from the other jurisdictions, and that collectively we are better for that sort of collection of technology, software, but also experience and skills. And I think in this instance, this is probably a system that we could see applying in the context of Crown Perth as well. We would want to trial it. We will, of course, as we do with all of our material change in the technology space, trial it in one jurisdiction and then roll it out to others if it's effective.
Coming back to page 1802 and the text box to do with transaction monitoring. See the fourth bullet point in that box. It says all banking transactions manually monitored by the financial crime team.
Yes.
Is that for the purpose of identifying deposits that are suspicious in the sense of evidencing potential structuring, smurfing, or deposits for non-gaming purposes?
That is correct.
Does the cage in Perth still have the frontline responsibility when processing transactions through the bank accounts to identify those suspicious transactions?
In consultation with the second line, so the responsibility extends to the second line. It starts with the first line, and then it extends to the second line. So the second line will continue to review transactions of that nature to identify whether or not patterns exist on a less immediate basis.
But just to understand, the cage still it has the responsibility of identifying suspicious transactions and raising a UAR?
They're technically, in accordance with the Act and the rules, they are required to identify unusual activity. They wouldn't identify suspicious activity. Suspicious activity is a determination made solely by experts in the second line function.
So they identify
based on a review of the unusual activity, but they are absolutely required to submit UARs, which is the unusual activity report.
So the review by the financial crime team that's noted here is a backup or second check, is it?
It's, in effect, a deeper investigation. So whenever an unusual activity report is received from anywhere in the front line, cage or otherwise, the second line team, so the financial crime team, will then investigate, review that UAR in the context of what we know about the customer. So in the context of the know your client, the KYC for that customer, together with their behavioral activity, and determine whether or not the activity actually constitutes something suspicious, which then triggers our reporting requirement to Austrac.
So what this bullet point says, though, is that all banking transactions are manually monitored by the team, not just the ones for which a UAR has been raised.
And that is correct. At that time, I believe we've moved away from that, but I need to confirm on that. But at that time, all banking transactions were reviewed by two individuals on, when I say banking transactions, I'm talking about customer, obviously, banking transactions, were reviewed by two individuals on the financial crime team, not as I said, not in an immediate fashion, but in a subsequent fashion to look for patterns and look for indicators of potential money laundering.
But let me understand now, the financial crime team does not review all banking transactions.
So I need to confirm that. My understanding is that with the introduction of multiple rules, automated transaction monitoring rules, we may have moved away from that, but I need to confirm. I apologize, it's not front of mind.
For Crown Perth and its banking transactions, is the review by the financial crime team, to whatever extent that is, does that occur in Melbourne or with the financial crime team in Perth?
It occurs across Crown Resorts Limited, so it could occur in Sydney, it could occur in Perth, and it could occur in Melbourne. Depends on where the actual resources are, but we don't distinguish between jurisdiction. We take a group approach, and in that group approach, some transactional activity investigations will be allocated to members on the Perth team, or members on the Melbourne team, or members on the Sydney team.
So what's the point of, what's the purpose of having financial crime team members located in Perth as opposed to just having them all housed in one location?
Well, from my perspective, it's about expertise and it's about excellence, and I will employ excellence and expertise wherever I can. And so we've been able to identify some terrific candidates for our financial crime risk team in, I think we have 7 now, and we're considering 2 others in Perth that add incredible value to our overall financial crime program for Crown Resorts.
This commission has heard some evidence about the way in which transactions were processed in the cage in Perth in years gone by, including the telegraphic transfers and how it was essentially a paper-based manual system with evidence of deposits being for early releases attached to the telegraphic transfer form. And I take it from the way you're nodding your head, you're familiar with the evidence that's been heard in that regard.
I am indeed.
Yeah. Does that process, that manual-based paper system, still occur in relation to the processing of telegraphic transfers?
There are manual elements to it. I should say that the financial crime process related to that, so the identification of unusual activity, has been fully digitized. We now receive digital UARs in a central repository. But in the case of IFTIs, there are still manual components to it, yes.
Right. And does the financial crime team have access to entirely the same information that is...
It does, and there's a 4-eye check on all of the documents.
Just finish the question.
I'm sorry. There was a pause in the screen.
Yeah, no, there was a pause here too. Does the financial crime team have access to the identical information available to the cage in terms of those transactions?
It does, yes. All the same systems are accessed by the financial crime team.
And is there an intention to phase out the manual processing of transactions by the cage?
Yes, there is.
And will that occur through a new automated system or one of the existing systems?
We're not yet at the point where we can make that determination. I think we're considering all options, but ultimately for the purpose of greater automation.
And what is the time frame for the transition from manual processing to fully automated?
None has been set at this point.
In respect of transaction monitoring as a component of the financial crime risks and compliance program, you identified that as being at a foundational level in May. Does it remain at a foundational level in your view?
Well, we've introduced additional rules. We've created a transaction monitoring council. I would say we're edging towards advanced, but we are certainly not there yet. And our ability to get to advanced or to get to optimal may depend on technology change. As I mentioned, for example, we're introducing a new case manager, which will be incredible help to the investigative team in uplifting our approach to transaction monitoring. So I'm encouraged that we are on the right path, but it will take some time.
Will there be a case manager at each property, or will that be a centralised process as well?
Everything will be centralised, so we will be agnostic as to jurisdiction.
Coming back to the Sentinel system, despite the limitations you've identified in relation to that system, given the recency of its introduction to Crown, is it your intention to retain that system, assuming it's proved to be effective?
I am not yet convinced on that. I am still open to considering other options, and I've had discussions with other providers that I've worked with in the past, but I have yet to make that determination.
Coming back to your PowerPoint presentation at page 1803, if we look at the third, in the left-hand column, the third component is employee due diligence. What you're identifying here is an AML CTF risk, not from the point of view of training or competence of employees, but from the point of view of integrity. Is that right?
That's correct.
And this is where the current program rates most highly, doesn't it, through the state-based licensing systems which have been in place for some time?
That is correct.
Would you agree that resourcing in terms of having competent staff properly trained is also an important feature of managing MLTF risk appropriately?
It's critical.
You've explained, I think, that you've been responsible for recruiting a large number of personnel into the second line of defence?
Correct.
But not so much the first line?
No, because as I said, the operational elements that are typically found in the first line are found in the second line under my team.
You'd agree that the general manager of the cage operations at a property holds a particularly important role in terms of the first line of defence?
I would agree with that, yes.
And that's because the cage is essentially the casino's bank where the majority of cash and other financial transactions are undertaken. You'd agree?
I agree with that, yes.
And you would agree that the general manager of the cage at each property is in effect responsible for the operation and management of the casino's bank, if you will, at that property?
I think that's a fair conclusion. I would reach the same one.
Have you reviewed the evidence given to this commission by Jared Campbell, the general manager of the cage at Crown Perth?
I have.
Do you have any concerns about his competence in respect of or approach to MLT risk identification and management?
I haven't assessed in a manner where I'm comfortable concluding or drawing an opinion on that. I certainly, some of the evidence was concerning to me. However, I wonder whether or not, and this is all speculation, but I wonder whether or not there was inadequate training in the past to fully prepare the manager of the cage for his responsibilities as a financial crime expert. Sorry, not as a financial crime expert, but in the financial crime space.
Do you think it's important as an aspect of your role for you to actually interrogate his competence and suitability for that role?
I sure do, which is precisely why I've established a second line assurance team to conduct testing in that regard, to conduct testing to understand where our gaps may exist in the first line, to test whether or not there is compliance with program requirements, policy requirements, et cetera. And that team, I think, will empower us to identify where there may be such gaps and then allow us to assist the first line with uplift.
But the second line that you have implemented has not yet thrown up any concerns about Mr. Campbell as a gap or a weakness?
They haven't reviewed the cage in Perth to this point, so they'd be unable to assess.
Have you reviewed the evidence given to this commission by David Brown, the General Manager of the cage at Crown Sydney?
I have, yes.
Do you have any concerns about his competence in respect of or approach to MLTF risk identification and management? I
am disappointed with what with the evidence provided by David in the context of his awareness or understanding of financial crime issues. Again, I cannot independently assess whether or not that is simply because he wasn't effectively trained. But it is clear to me that during all relevant times, particularly in relation to the aggregation issue, transactions should have been identified that weren't identified, and that is problematic.
Is the position in relation to Mr. Brown,
Yes.
as far as you're concerned, the same as Mr. Campbell? You have a responsibility to interrogate his suitability, but you're awaiting feedback from the second line in that regard?
Yes.
Separately from this issue of actually looking into the whys and wherefores of their suitability for the role, having regard to the fact that both gentlemen were involved in the cage operations at Crown Perth over a period of many years, including that period of 2014 to 2017, when,
Yes.
according to the Bergen findings, money laundering was facilitated through the operation of the Riverbank Investments account. From a MLTF risk management perspective, do you consider it in any event appropriate for either of them to hold a position as general manager of cage at a Crown property going forward?
I will say that I question their suitability. As I said, I'm not able to conclude, but I do question their suitability, and I think interrogation is completely appropriate. If I may supplement that, to me, and in my experience, the first line is often only as good as the second line is. So if the second line is empowering the first line to perform their obligations and discharge their obligations in the financial crime space, that they should be empowered by the second line to do so. Based on my understanding of both from David Brown's evidence and Jared's evidence, but also my review of what occurred in the past through the Riverbank and South Bank accounts, and also through what was raised through the Bergen Inquiry and Victoria Royal Commission, et cetera, is that the second line was inadequate, and the advice provided by the second line was inadequate, and the decisions made by the second line were inadequate. The judgment of the second line was inadequate, and what troubles me most is that I don't believe that the board were put in a position to discharge their obligations because they weren't informed appropriately of some of the challenges that existed in the financial crime space.
The first line is called the first line for a reason, though, isn't it? Because it owns the
Yes.
risk, and it is the first point at which the risk is to be identified and managed.
It is the first point, but it should be taken in conjunction with the second and third line, because that's why you have three lines. Essentially, your second line should support your first line, your third line should support both. And that's why you have the three lines of defense. And frankly, if one of the functions is not operating properly, then it is bound to impact the other two.
But the first line needs to be robust, doesn't it?
It does, yes.
And the question that I most recently put to you in relation to Mr. Campbell and Mr. Brown was, separately from their ability to robustly perform that first line of defence, whether simply as a matter of perception or culture, given their history, you consider it appropriate for them to hold those positions of general manager, cage of a property going forward?
I'm afraid I don't consider it appropriate. I haven't yet made a determination on whether or not it's appropriate, but I am my concern. I have concerns, and I will pursue those concerns and have pursued those concerns.
Mr. Blackburn, I now want to talk to you about the assurance component at 1804 of the PowerPoint presentation, the text box. you address the component of assurance. Now, what you're referring to here is the process by which the implementation of the financial crime and compliance programs is routinely tested in order to ascertain to what extent it's working effectively in practice. Is that the gist of it?
Correct. That's it.
It's a fundamentally important part of any program, you would agree?
I would agree with that, yes.
Because the effectiveness of the program to mitigate risk is ultimately to be judged by whether in practice and in fact, as implemented, it is effective in identifying and managing relevant risks. You'd agree?
Right.
I'm sorry to interrupt, Commissioners, but contrary to what was happening this morning that was on the public screen, it's now been removed, I think.
This particular document?
Yes.
Yes, right. Now,
Mr. Blackburn, it's in this area, sorry, if we go back to page 1804, please. It's now in this area of assurance that you perceive the current program is least developed, is that right?
At that point in time, I believe it was. I'm happy to advise that I have hired some fantastic leaders in this space onto the financial crime risk team or financial crime and compliance team. And we've developed a plan of an assurance plan. My perspective is that has shifted considerably since May.
So you identified it as being only at an initial stage in May. Where do you see it sitting now?
Close to foundational, but not quite there yet until we get all of our staff members on board.
Now, if we go to your witness statement at page 1025, paragraph 109, it was the second line of defence in particular that you saw as a weak link in the program.
Correct. Correct. Let me explain why. In the program as at May, there were 3 people doing, and they were based in the compliance team, doing gaming assurance. So testing the front line against gaming policies, gaming requirements, and statements and procedures. That, to my mind, is inadequate for an operation the size of Crown, which is precisely why I proposed the considerable uplift.
If I can just take you to paragraph 107 on this page, and if you here you're responding to a question about whether the joint program has been properly implemented in practice.
Yes.
The moderator may be able to pop the question out for you, but you answer, you cast your answer in a negative way, in the sense that you say you have no reason to believe that the business units are not complying with their requirements. But isn't it the case that because the assurance function has not yet reached foundational status, you can't be sure whether the business units are complying with the requirements of the program or not?
Correct. I can't be sure, but I would expect in an organization like this, based on my experience, that I would have had at least a handful of escalations suggesting that they aren't by this point, if that was the case. So whilst I don't take full comfort from it, I do take some comfort from the fact that I have not had escalations of that nature.
But there's some areas that just haven't been reviewed. For example, the cage operations.
Well, I believe cage operations was reviewed by the 3rd line, but 2nd line has not reviewed the cage operations at this point. So that is considered under our assurance plan.
So you may or may not be getting an accurate read on whether the existing joint program is being effectively implemented at an operational level as we sit here today?
I can't say with absolute confidence that it is, but I also can't say that it isn't.
Right. Now, at paragraph 110 on this page of your witness statement, you talk about the broader testing and assurance plan that's being designed presently that will be rolled out in the course of the coming months and next financial year.
Yes.
What precisely is that time frame?
Oh, well, it's already started. We've already started the work, so we've got a handful of people already. I believe we have 3 on that team now. We're expanding quickly. It'll be one of the largest second-line assurance teams in the financial crime space in the country. And our work is already underway. So we're already doing second-line assurance on a number of deliverables, both from the first line and the second line. So, for example, the Deloitte Phase 1 review, we, of course, received a number of recommendations. I believe it was 29. 27 of those recommendations have been implemented to date, and assurance has been applied by the second line over those 27, regardless of where they reside, if they reside in the first or second line. So the work is underway.
When will the rollout be completed?
I anticipate that we will have all roles filled by the end of December, which means the full program can be launched in January. However, as I said, work is already underway.
When will the rollout be completed?
I feel I've answered that question, but perhaps you can...
So there's a plan that's being designed. You
Yes.
say that it will be rolled out during the course of the coming months and next financial year. When will that rollout that occurs over the coming months and next financial year be completed?
Okay, understood. Sorry, I didn't realize it was just a point question. The rollout will be completed once all of the assurance efforts, once all of the assurance exercises have been completed as per the plan. So the plan considers a number of assurance exercises over the course of the fiscal year. Each one will be completed in due course. Collectively, when we complete all of those assurance exercises, it will be complete for that year. But at no point will it ever be fully complete, because we will then construct a new plan for the following fiscal year, conduct additional exercises to create an ongoing program.
When will...
Does that answer your question? Or
when will the plan that's currently being designed be rolled out for the current, will be completed?
could I ask you to just define rollout, because I think we may be saying the same thing. Do you mean rollout as in publishing a plan that will then be pursued, or do you mean rollout as the plan will be complete?
Mr. Blackburn, can you just please go to your words in paragraph 100 of your witness statement? What are you talking about there when you talk about a new plan being designed and rolled out during the course of the coming months and next financial year?
Yeah, so what I mean by that is, sorry, that's what I thought I was saying. What I mean by that is we create a plan that has a number of exercises in that plan. Those exercises are reviews or testing assurance programs in respect of specific areas of risk. We will conduct those on an ongoing basis over the course of the year. By the end of the year, the plan will be complete and a new plan will be developed for the following year. So the rollout is an ongoing exercise as the plan is conducted.
I want to ask you now about standard operating procedures. Is it correct to look at the implementation of the joint program as occurring not exclusively, but in important ways by way of written standard operating procedures supported by written policies?
So standard operating procedures, if I understand your question, are yes, they're critical in the rollout, or sorry, I don't want to use that again, in the delivery of the AML-CTF program.
Do you consider that the current standard operating procedures at Perth Casino are effective to implement the existing joint program?
I'm afraid I can't answer that, but I have no reason to believe they aren't.
Is it the intention, well, sorry, I'll just go back there. Again, without your second line assurance, is it the case, having been sort of fully embedded, it's not possible to say one way or the other?
I think that's correct. However, I do take comfort in the fact that I've had no concerns raised to date. This is the kind of thing you would identify through day-to-day practice and then have escalated. I haven't had any escalations to date. However, I know in certain instances the businesses have produced standard operating procedures based on the program, on the policy in the program and the policy in the underlying procedures that have not been vetted by my team.
Is it the intention as part of the new change program to completely rewrite the standard operating procedures for Perth Casino?
I think there's an opportunity to consolidate the standard operating procedures, but I would not say it's the intention to completely rewrite, because in many cases, as I understand it, there are elements that are okay and that the Perth Casino staff understand and have operationalized. So I'd be cautious about rewriting the entire set of procedures, but I think they need to be obviously updated to reflect the program as it evolves.
Right, if we just go back to the PowerPoint presentation, CRW 510-0731797 at page 1813. So this is the slide that is dealing primarily with the document uplift component of the change program. Is that right?
That's correct. And it has changed since that was produced. We've taken a more simplified approach, whilst we will continue to have the group policy and program at the second from top level. We're choosing to integrate the standards into Part A and Part B. So it'll be a comprehensive Part A and Part B rather than having an underlying policy and procedures document. And then, of course, the procedures which belong to the first line will need to be amended and adjusted accordingly.
I just ask you to explain in that line to do with standards, third column, there's a reference to division standards, and ask you what you mean by division there.
Regional, to the extent that standards may differ based on state law. So if there's nuance for jurisdiction, then we would introduce that nuance through the standards.
And is it envisaged that the new documentation will be bespoke for each property?
No, under the joint AML, under the AML Act and rules, we're permitted to have a joint AML program that applies to all reporting entities within the DBG. So the designated business group is Crown Resorts Limited, and the reporting entities will remain Crown Perth, Crown Melbourne, and Crown Sydney. And they will, the same program will apply to all three.
Now, if I can come
Where it may differ is in the procedures, depending on systems and local requirements.
So there may be standard operating procedures that will be bespoke for each property.
It very likely will be, based on the current technology used in the different jurisdictions may differ. So for example, the customer management system may differ jurisdiction to jurisdiction, and in those instances, we'll need to ensure that the procedures are technically appropriate for that jurisdiction.
And if we go back to your witness statement at paragraph 114, page 1026, is it correct understanding that the individual business units will prepare those specific standard operating procedures, not the financial crime team.
That is absolutely correct. It's a first line obligation. And in fact, it helps with training and education for the first line to require the first line to compose and construct their standard operating procedures based on the policy and based on the program, so that they're required to consider the obligations of the program. They will, however, be reviewed by the second line to ensure consistency and to ensure that they are appropriate.
Ms.
What does
Cale,
it-
could I just interrupt? In that previous document, which was about the documents, there was no reference, or I couldn't see a reference to the casino operations manual. Is that,
Yes, the casino yes.
Where would the casino operations manual fit? Given the context is still AML/CTF, where would the casino operations manual fit?
So what I'd like to see, Commissioner, is further integration of those standard operating procedures that relate to AML and CTF into the casino manual, But at this point in time, many of them exist outside of that document. I'm keen for them to be consolidated into that document for basically for accessibility and simplicity.
All right, thank you.
Of course.
The standard operating procedures that are to be prepared at the individual property level, can I ask how that works
Yes.
in practice? For a standard operating procedure that relates to the operations of the cage and count in Perth, is that actually prepared by the cage, or is it prepared by senior executives at Crown Perth?
I think it will depend on how each business chooses to approach it. But in my experience, it's mid-level executives in the jurisdiction. So, for example, I would expect the GM of the cage in Perth to at least do the initial construction of the document.
And you're aware that standard operating procedures have been amended since your arrival at the Crown Perth level?
Yes, I've become aware of that. Unfortunately, I think there are instances that we've identified where we have not been engaged, which is problematic, particularly considering that we have indicated widely that we intend to review all procedures before they're finalized. So disappointingly so, yes, but I suspect that is a point in time issue before we were had sufficient capacity to actually conduct that second line review.
So just to be clear, there are standing operating procedures that have been amended in Perth this year or in the latter part of last year that have not been reviewed by a second line of defence.
That is correct. This is one of the challenges of an evolving team, is that until we have the capacity, we're not quite in a position to do everything we'd hope to do.
And can I just ask you about this particular, a notation on this standing operating procedure, which is to just be shown on the room screens, CRW 701 006 3741. If we go to page 3747, see at the bottom there of the text, it says these SOPs, this is not a unique notation on this from our research, Mr. Blackburn. Says that
Yes.
SOPs are to be read in conjunction with the internal controls. Cage shift manager above has the right to override these SEPs, but must not breach any of the internal controls. Do you know what the internal controls are that are being referred to there?
I don't. I'm afraid not.
Do you know what the rationale is for the cage shift manager or above having the right to override the SOPs in the circumstances articulated there?
I'm afraid not. This when this was included as a document that we would be reviewing, I did review it yesterday. I had a quick look at it yesterday, and it's not a document I'm familiar with.
Do you expect that this notation will likely survive in the document uplift?
I can assure you it will not.
Mr. Campbell gave evidence to this commission that there's a new role of cage financial integrity manager within the cage at Crown Perth. Was that an initiative that you introduced?
It wasn't. As I understand it, it was an initiative introduced through the cage in Perth, but also in consultation with John Salomone here, the CFO for Crown Resorts here in Melbourne.
What is the purpose of the role?
I don't know, but my suspicion, and I may have had casual reference to this or in a conversation, but is to perform QA, so quality assurance on reviews.
Does it have anything to do with identifying or managing AML CTF risk?
I would expect that it would, as I would expect that it is one of those first line roles intended to supplement the first line's ability to at least initially identify risk.
And do you know how it intersects with, that role intersects with the first line role that cage staff have who are actually processing transactions?
I'm afraid I don't. It's not within my purview.
And do you have any idea of how the financial integrity manager role intersects with the financial crime team role?
So with the second line, you mean?
Yes.
The financial crime in the team in the second line?
Yes.
Yes, in the same way the role of any first line employee would be, which is to identify risk and escalate it.
Do you envisage that the role of cage financial integrity manager is likely to remain a role within the cage once your change program is introduced?
I wouldn't anticipate any reduction in first line staff aimed at integrity. In fact, I would support that on all counts. So if I don't know if it's the intention for that role to remain, of course, because it's not within my group, but I would support it remaining to the extent that it assists with the integrity of the function.
Can I ask you about the current management structure in respect of managing AML CTF risk within the Crown Group, specifically Crown Perth, by going to the latest, I think it's the latest organisational chart for Crown Perth as at 20 October 2021, that's CRW 70100950021.
Yes.
Is it, if we go over to the next page, may we assume that this management structure, insofar as it relates to AML and financial crime generally, is the structure that will pertain when the change program is implemented?
Yes, so I will say this is yesterday was the first time I'd seen this document, and there are roles missing from the financial crime and compliance team that I think the document is imperfect.
All right. Now, one feature of it appears to be that there is no general manager or higher role in respect of financial crime or AML CTF located in Perth.
No, disappointingly so. I certainly advertised in Perth, as I advertised in Melbourne and Sydney, because as I said, I'm agnostic to location. I simply want the best experienced people I can bring in to manage the risk. And unfortunately, we had very, very few applicants in Perth, which didn't surprise me, given that the financial crime risk industry in Perth is not highly developed in the same way that it is in Sydney or Melbourne. So we did have some applicants, however, insufficient experience amongst those applicants.
What is the benefit that you perceived from having a general manager or higher located in Perth that led to you wanting to recruit?
I like, frankly, the availability of somebody at the senior level on the ground. However, I do recognize that what I've built into my contracts with all of my general managers and EGMs in financial crime and compliance is that they spend at least a third of their time in the cities that they are not based in. So I do anticipate we will have many EGMs and GMs, including myself, on the ground in Perth often.
When we go to paragraph 124 of your witness statement, page 1028, and you talk about the 7 team members that are based in Perth.
Yes.
Obviously, they're not at general manager level or higher. What level are they?
So the next level down is where at least one of them is, at the sort of head of or director level. And then across the range for the remainder. So they're at different levels, but the most senior is a woman named Danielle Slattery, whom I believe the BCRC has met with. And she is next to an executive level.
And do any of the personnel that you mentioned there have a dotted line reporting through to Crown Perth management, such as Lonnie Bossy?
No, I am, as a financial crime person and a compliance risk management person, I am resistant to the idea of dotted lines into the business for integrity functions. So my expectation is that they will be there, available to Lonnie should he need them, and he does contact them frequently. However, I would not expect a dotted line into a non-integrity function.
Right. So your point is to say that second line and third line need to be not just independent of each other, but certainly independent of first line. That's
my perspective, yes.
Now, if we come back to the PowerPoint presentation, please, CRW 510-0731797 at page 1815. You're discussing their governance in respect of oversight by the board and senior management in relation to financial crime and compliance. And you refer there, we can see from the shaded boxes, to the establishment of a Financial Crime Oversight Committee, or let's call that FCOC for short, to replace the existing AML-CTF committee. That I understand from your previous evidence you intend to be within the second line of defence.
The FCOC will have membership from all lines of defence. But the point of the FCOC, I will chair the FCOC. However, the expectation is that the businesses led in the FCOC, that's at the CEO level, will present their management of financial crime at every one of those FCOC committee meetings. So it reinforces that the obligations are owned by the first line, and that the second line is there to assist and to apply oversight, but not to fulfill the obligations. So my expectation is that each of Lonnie and the CEOs of the other jurisdictions will present at the FCOC.
Well, present, they're intended to be members, aren't they?
Yes, but it goes beyond membership. It goes to the point where they are actually presenting their approach to managing financial crime risk, and they will be tasked with how they are meeting their obligations under the AML-CTF program.
But let me just understand, the FCOC is comprised of members from first line, second and third lines of defence, is that right?
Correct.
And so what is the purpose of the committee?
To identify, manage and mitigate financial crime. So it is the top level committee. Beneath it is the Financial Crime Working Group, as you see, which the expectation of the Financial Crime Working Group, which also has representation from all jurisdictions and all businesses, is to identify risk, identify gaps in approaches, but also to explain how each of those businesses is managing and mitigating financial crime risk. That is then fed into the FCOC so that the FCOC can take action, but also to then report to the board, the business leaders to report to the board on how they are managing financial crime risk.
So how does that concept intersect with the notion that the 3 lines of defence need to be independent of each other?
It's not a decision-making body per se. The decisions will be made by the individual units or the individual CEOs, however, in consultation obviously with me as I apply oversight. But it is not a determination committee.
Now, if we can return to Part A of the current joint program, just on the hearing room screens, please, CRW 514-002-0110. At page 0120, section 7.4, it sets out the role and responsibility of the ERCC. There does not appear to be a role for the ERCC in the change program that you are developing. Is that right?
Yes, that is correct. The ERCC will be confined to risk and compliance.
Well, what does that, so not related to money?
Not related to financial crime. Financial crime will be dealt with through the FCWG and the FCOC as a separate risk entity.
So let me just make sure I understand
of course
clearly what you're saying. In relation to the identification and management of specifically money laundering and terrorism financing risk or financial crime risk, the ERCC will have no jurisdiction in relation to that, but it will in relation
that is
to
correct.
Risks.
That is correct, because the FCOC and the FCWG will have responsibilities in respect of financial crime risk, so AML and CTF, and both the ERCC and the FCOC will also report to the board risk committees so that matters are escalated concurrently.
Do you see the board of Burswood Limited having a role in relation to the identification and management of MLTF risk in respect of Perth casino operations?
I do for certain. So my expectation is that the FCOC will also, and Lonnie Bossy in particular, will also present to the board on of Burswood on managing financial crime risk, together with me. Of course, I will always be present at the board as well.
But what will the role of the Burswood Limited board be in relation to the identification and management of MLTF risk?
Well, let's be clear. The board, under no legislation, is required to identify financial crime risk. The boards are required to apply oversight so that the board members can discharge. The directors of the boards are required to discharge their obligation to apply oversight through collection of reporting and advice from senior management and from management. That will continue to be the role, that has been the role of Burswood, and that will continue to be the role of Burswood.
How do you see Burswood's oversight role that you've just explained intersecting with the role of CRL Board's Risk Management Committee?
In this absolutely the same fashion. So to date, every paper I presented to the board of CRL in respect to financial crime and compliance is also presented to the Burswood board.
So do you see the oversight functions of the CRL Board Risk Management Committee and the Burswood Limited Board as basically being duplicates of each other?
Yes, I think all boards of directors are required to fulfill the same obligations, both in accordance with law and in accordance with Austrict's expectations, which is to apply that effective oversight, to understand the program, and to direct management in how to address risk.
You identified in your May memo to the board, that's the CRL board, that a key action of the change program was to clarify roles and responsibilities around the first and second lines of defence.
Yes.
And that's an important aspect of the remediation program going forward, isn't it?
It is indeed.
And do you agree that it'll be of great importance to identify and define the role of the Burswood Limited Board in overseeing MLTF risk?
Yes, just as well, it's an extension of the role and responsibility of the CRL board, or the Crown Melbourne board, or the Crown Sydney board. All of those boards have the identical obligations in respect of their division or their entity.
Yeah, and in particular, that clarification will need to be very specific about whether and to what extent the FCOC and FCWT are accountable to the Burswood Limited Board. Would you agree?
I would agree with that, yes.
If we go to paragraph 118, page 1027 of your witness statement. You refer back to the PowerPoint presentation with a target date of 31 December 2022 to achieve advanced state for financial crime maturity. Are you presently of the view that that target can be met?
I am. However, I'm aware of and conscious of events that may occur in the interim, which could challenge those delivery dates. However, as it stands now, I believe we can meet those delivery dates.
What are those events that you're aware of?
The outcome, of course, of the Perth Royal Commission could have bearing on our ability to deliver on time. The outcome of any AUSTRAC enforcement investigation, there are currently two, one in respect of Burswood, one in respect of Melbourne. The outcome of those enforcement investigations could challenge our progress.
And that's because,
or our path.
That's because those investigations effectively suck resources that might otherwise be devoted to developing and implementing the change program. Is that the essence?
Precisely. If you consider the past three examples of enforcement actions by AUSTRAC, in each instance, Tabcorp, CBA, and Westpac, those organizations were required to supplement their existing resources with externals, to a considerable number of externals to assist with managing the outcomes of those enforcement actions.
That's probably an appropriate point.
Yes. Mr. Blackburn, we break for lunch here now.
Okay.
We will finish today, but I can't give you a finishing time. We'll take breaks.
No problem at all.
We're going into our afternoon, your evening. If you need to a break, please just let us know.
Oh, no problem at all. Thank you for that. That's very kind of you, but I'm good. Thanks.
So it will adjourn now to 2 p.m.